Hi, this is immigration attorney Erin, and I'm here today to talk to you about who you can get to the United States from your family. So when you're thinking about the topic of bringing family here, you want to think about two main categories of family members. So there's going to be immediate relatives, and then there are the family preference categories. So in the immediate relative side of things, immediate relative does not mean, of course, it's immigration law, it's tricky. It doesn't mean your actual immediate relative. That definition would be a spouse, parent, or child of a U.S. citizen. So if you're a resident, you're not going to fall into the immediate category. Your relative isn't going to be an immediate relative under U.S. immigration law. So why that matters is because the preference category side of family immigration, they all have wait times. So they all have quotas, I should say, of how many people the U.S. is going to let in under each of those categories. And there are 5 of those categories. There's F1, F2A, F2B, F3, and F4, and I'll run through those in just a minute. But with the immediate relatives, you'll notice that only U.S. citizens can petition for those immediate relatives, and since there's no quota for the immediate relatives, there's also no backlog, which means there's no extra wait time. The only wait time that you're going to have involved with the immediate relatives is going to be the wait time of waiting for that petition to get approved by USCIS, and then going through the consular processing or the adjustment of status if they're getting their status from the United States. So one thing to note with the child part of the immediate relatives, like the child category, is that child has to be under 21 to count as a child. So child has a very quite actually complex definition in immigration law, which could be a whole nother video when it comes to thinking about whether a stepchild is going to be your child per immigration law, or whether an adopted child is going to count as a child for immigration purposes. So those are some things to think about also when you're considering, which category your family member is falling into if you're thinking about petitioning for them, or if you're the person who wants to be petitioned for. So let's go over to the preference categories then, since I've described the difference between the immediate relatives, which is no quota, no extra wait time, and then the preference categories, which is the quota and typically will, as of now, has a wait time. And that has to do with the visa bulletin, which is a whole nother little world that we can talk about at a later date. So the first preference category, and they all have different wait times. The first one is going to be the unmarried sons and daughters of U.S. citizens. So, of course, sons and daughters is different than children, different than child in immigration law. So the son and daughter would be someone who's 21 and over, still has that parent-child relationship, and they're unmarried, okay? Then going down to F2, there's F2A and B, and those are both related to residents. The other 3 categories, you have to have the relationship to a citizen of the United States. The F2, 2A and 2B relate to someone who's a resident and petitioning from the United States. So the first one is going to be for a spouse or child of a resident, and then the second one is an unmarried son or daughter of a resident. And those terms have the same meanings as we just spoke about as when they're in the immediate relative category or the preference F1 category. So one thing to notice is that there's no option to petition for a son or daughter who is married. So just keep that in mind before, you might want to go stop the wedding or pause the wedding if you're waiting for, or if you're planning on petitioning for that son or daughter. They also have much longer wait times. For the F2B, typically the wait time is going to be longer. And okay, so moving right along to F3, that's going to be the married sons and daughters of U.S. citizens. So if you're a citizen, you can petition for that married son or daughter. It's not a child, the married son or daughter. And then F4 is going to be the sibling of a U.S. citizen. So you can bring your if you're a U.S. citizen, you can bring your sibling here. And that typically has the longest wait period, the longest backlog in the visa bulletin. So I would say one tip, if you're thinking about if you have siblings at all and you get your citizenship, I would start petitioning for those siblings right away, even if they're just kind of interested, because that wait time is well over 10 years. So they might change their mind maybe once, maybe a few times within that time period. So just get that petition in, because the backlog is so extensive, and I don't anticipate that one speeding up, because people are going to keep on petitioning for their siblings, and unlike having a more limited number of maybe children you're going to petition for, or they're aging out or getting married or what have you, siblings, you're just it's a relationship that's not going to change based on marriage or what was the other thing I was going to say? Marriage or their age. So and people can have a lot of siblings, so that one's quite backlogged. So those are that's an overview of who you can bring to the United States, who you can petition for. The petition that you would use is called the I-130 petition for alien relative. Even if they're not from Mars, it's still called alien on all the forms, and you'll see that designation there. So you get that petition in, then after you petition for them, or in some cases concurrently, we can get into this more in another video, you're going to do either adjustment of status or consular processing. So adjustment of status is going to happen from within the United States if they're already here. Then the consular processing is something that would happen if they're outside the United States, or they need to leave to re-enter and come back in with a waiver or something like that if there are other issues. So if you have any questions further about bringing a family member here, I'd be so happy to answer those. I love doing family cases. I brought my own husband here, and it was his own family case, so I kind of know some of the pain of going through that and being separated, having to bring a family member here. So if you want to reach out and talk to me more, I'd be more than happy to do that. You can email me at erin@liechtylaw.com. It's LIECHTY law.com, and I will definitely respond to you quickly, and we can talk about your case and getting your loved one here. All right, bye for now.